Good evening and welcome to the first lesson in Legal 115, Civil Litigation Procedures. I am Alicia Turner, your instructor for the spring 2017 semester. Before we get started, let's talk a little bit about just a quick overview of what litigation is. Litigation is the process by which Party A decides to sue Party B because Party A thinks Party B did something to cause damage or loss of money or some sort of fraud. There's any number of reasons why Party A sues Party B. So let's jump into an overview of what civil litigation is. We are all in the paralegal program here at Miramar College. And there are several ways that you can become a paralegal. You can be qualified as a paralegal by education, training, or work experience. There used to be a program where if you worked for so long as a legal assistant under an attorney, you could become quote unquote grandfathered in to this thing called paralegal. Now, that program has been done away with. So now paralegals are really more so by going through programs such as this. They have to be programs that are certified by the ABA. I know our program went through a huge recertification this past summer, and it's a pretty big process. And so we as paralegals, we are employed by attorneys, we're employed by law firms, we can work for government agencies, different corporations. There are specific tasks that we can be assigned to do, and we must work under an active member of the California State Bar. And there at the bottom, you can't see them very well, are the code sections that govern who's a paralegal or what a paralegal is. Here's a little bit more of an in-depth look at what it means to be a paralegal. Someone who's qualified by education, training, or work experience. This is pretty much a copy of this. This is the code section for the slide that you previously saw. Again, this is more of what the Business and Professions Code defines as a paralegal. And so when you're looking at law firms bill in a few different ways. It's not just one way. A law firm can bill on a contingency fee, meaning that at the end of the case, if you get an award, then the law firm will receive a percentage of that judgment. Usually it's about 30 to 40%. If there is no recovery, then there's no fee. And it doesn't matter how much the law firm has actually put into the case already. If there's no recovery, again, there's no fee. Most law firms bill on an hourly basis. So the minute we pick up the phone, the minute we send out an email, the minute we start preparing a motion, doing research, we go to a meeting, we attend a deposition, those things are being billed hourly. The clock starts running the minute we start working on the case. And then there are certain types of cases where it might be billed on a flat fee. I know workers' comp can be billed on a flat fee, divorce, immigration. I talked to a lady a little while ago. They do insurance subrogation, again, on flat fee, depending on the type of case that it might be that they're handling. And when you go and interview for a position at a law firm, it is very important that you ask the question, what is the billing requirement for this law firm? And the billing requirements vary by firm. I worked at a firm where I had to bill 1,800 hours a year. And once I asked that question, what is your billing hour requirement? And then they give me a response. My follow-up question to that is, do you have enough work to ensure that I can meet my billing requirements? I don't want to be sitting around twiddling my thumb and not making my billing requirements. A lot of times your bonus is tied into your billing, you meeting your billing requirement. So when we are working as a paralegal, the role of the paralegal is so different depending on the firm that you're working in. In your smaller firms, you will do a lot more. In your larger firms, you could do a little bit less. I have issued subpoenas. I have researched witnesses and located witnesses, researched the plaintiffs, prepared discovery responses, scheduled the deposition notices, and if subpoenas are required, I do those as well. When we get ready for trial, I am very busy. I do the trial exhibits, the exhibit list. I prepare video clips of witnesses that will be played to the jury. I cite check briefs. That means I go through, and every time opposing counsel quotes a case, I go look at the case and make sure that cite is actually in that actual case. I fact check the brief, meaning, again, the things that are quoted in the case are actually true.